Good day everyone, we are Group D from Tutorial 15 and this is our video presentation for UNL 6113 Contract Law 1. My name is Shanmita and I will begin by introducing our group members. Our group consists of Kausalya, Muklis, Kavin and myself Shanmita. Each of us will be responsible for analyzing different legal issues arising from the given legal scenario. The scenario revolves around Ida, who becomes involved in a series of contractual disputes that raise important questions under contract law. These disputes include a company advertisement promising a monetary reward, a marriage-related agreement between two fathers, a family arrangement involving financial support, a government scholarship bond, and negotiations for the purchase of a house. Through these situations, the case raises several key principles of contract law such as offer and acceptance, unilateral contracts, intention to create legal relations, consideration, privity of contract, penalty clauses, and the legal effect of counteroffers. The purpose of this presentation is to critically discuss and advise all parties involved by applying relevant statutory provisions under the Contract Act 1950 and supported by decided case laws. The presentation will be structured as follows. The next speaker, Kausalya, will discuss issue 1, which examines whether a company advertisement can constitute a unilateral contract. I will then return to analyze issue 2, which concerns a marriage agreement and the application of the doctrine of privity of contract. This will be followed by issue 3 and 4 and finally issue 5 together with the overall conclusion. I will now pass the presentation to the next speaker to discuss issue 1.
Good day everyone, my name is Kausalya and I'll be explaining the first issue. Let's begin our analysis with the first and perhaps most public facing disputes, which is the immune patch advertisement. Here are the core facts of this situation. Cepat Sehat Sendirian Berhad, a pharmaceutical company, launched a nationwide campaign. Their advertisement made a very specific promise, which is 10,000 ringgit Malaysia will be paid to anyone who uses the immune patch daily for 30 days as directed and still develops a severe skin allergy. Crucially demonstrate their sincerity. Publicly they declared that 100,000 ringgit had been deposited with the June bank. So Ida, a nurse with a sensitive skin, saw this advertisement. Relying on this promise, she purchased the product, used it exactly as instructed, and unfortunately, after 3 weeks, developed a serious allergy rash. She rightfully stepped forward to claim the 10,000 ringgit reward. However, Cepat Sehat refused. They said the advertisement was merely an invitation to treat with no real intention to pay anyone. So let's look at the issues of this situation. So first and most fundamentally, which is whether this advertisement constituted a valid unilateral offer or was it merely an invitation to treat? In other words, was it a promise open to the whole world that could be accepted by performance, or was it just an invitation for customers to make an offer by buying the product? And the second issue was whether the Cepat Sehat legally bound to pay Ida the 10,000 ringgit. To answer this, the famous case which is held in 1893, which is Khalil against Carbolic Spokeball Company. The facts are strangely similar with this situation. A company advertised that it would pay £100 to anyone who used its smoke ball as directed and still contracted influenza. They even deposit £1,000 in a bank to show their sincerity. When Mrs. Khalil fell ill after using it accordingly, the company refused, and the Court of Appeal held that there is a binding unilateral offer. So the judgment established several vital principles, which is an advertisement can be a clear offer to the world, acceptance is completely by performing the stated conditions, and depositing money is a powerful indicator of a serious intention to create legal. And also, this common law principle is supported by our own Section 2, Paragraph A of the Contracts Act 1950, which defines a proposal or an offer as a willingness to do something with a view to obtaining the assent of another. So let's begin with the authorities at conclusion. So now let's apply the authorities to IDA's application. First, the clarity of the promise. The advertisement was not a vague promotional hype. It stated a specific sum, a specific action, and a specific result. This mirrors the precise terms in Carlyle case. Second, this is the most compelling point, the univocal intention to be bound. Chapa Sehat didn't just make a claim, they backed it with a substantial deposit with 100,000 ringgit Malaysia. In law, this acts fundamentally undermines their later claim of it being a gimmick. Let's look at the Khalil case. Why would the money be deposited unless to show sincerity? This acts objectively signals to the public, including IDA, that they intend to be taken seriously. Third, complete performance. Ida did not just buy the patch, she performed the very act required, she used it daily as directed. Her acceptance was through her conduct, and even she got the serious allergy. Now let's talk about Chapar Seha's perspective. They might argue it was merely a gimmick, exaggerated sales, talk not meant to be taken literally. This defense collapsed in the face of the deposited money. They might also argue Ida's act of buying the patch was the contract, not the advertisement, but in the unilateral contract, the advertisement is the offer and buying or using is the beginning of the performance, not a counter offer. Therefore, our conclusion is clear. A valid unilateral contract was formed. Chapa Seha's advertisement was an offer to the world. Ida accepted through a full performance. The deposit of the 100,000 ringgit is fertile to the gimmick defense. Our advice flows from this conclusion. For Ida, you are one very strong legal ground. You should formally demand payment, citing Khalil against Carbolic's football case. If refused, your claim in court has high prospects of success. Document everything. For the proof, the advertisement, your purchase receipt and medical proof of the allergy. To Chapa Sehat Sanidam Berhad, the advice will be given is your legal position is weak. The defense of promotional gimmick is highly unlikely to succeed before a judge familiar with Khalil case. You should honor the promise to avoid not only legal liability but also significant reputationally damage. In future marketing, if you do not wish to bound, avoid making specific performance-based promises backed by demonstrative acts like a deposit. This case reminds us that in the eyes of the law, a public promise with a clear terms, especially backed by a show of commitment, is not just marketing, it can be a binding contract.
Hi again everyone. I will now continue the presentation by discussing issue 2. Issue 2 concerns a marriage agreement made between Rahman and his close friend Johan. Both men agreed that if their children, Ida and Hafiz, married each other, each father would give 50,000 ringgit Malaysia to the couple as wedding gift. The marriage subsequently took place. Rahman fulfilled his promise by paying 50,000 ringgit Malaysia. However, Johan passed away before making payment. Ida and Hafiz then attempted to claim the 50,000 ringgit Malaysia from Johan's estate. However, the executor refused the claim, arguing that Ida and Hafiz were not parties to the contract. The legal issue here is whether Ida and Hafiz, as beneficiaries of the agreement, can enforce the promise made between Rahman and Johan. This issue involves the doctrine of privity of contract. Under the doctrine of privity, only parties to a contract are entitled to enforce its terms. A third party, even if they benefit from the contract, generally has no legal right to sue upon it. The relevant statutory provision is Section 2 Clause D of the Contract Act 1950, which requires that consideration must move from the promisee. This reinforces the principle that contractual rights are limited to the parties who entered into the agreement. The leading authority on this issue is Tweddle v. Atkinson. In this case, an agreement was made between two fathers that a sum of money would be paid to their son upon marriage. However, the son was not allowed to enforce the agreement, even though it was clearly made for his benefit. The court held that a third party who provided no consideration cannot enforce a contract. This case is highly relevant to the present facts, as both situations involve a marriage agreement made by parents for the benefit of their children. Another important authority is Bestwick v. Bestwick, where the House of Lords reaffirmed the general rule of privity of contract. Although the widow succeeded in her capacity as an administrator of the estate, the court made it clear that third parties generally cannot enforce contracts made for their benefit. Applying these principles to the present case, the agreement was clearly formed between Rahman and Johan only. Ida and Hafiz were not parties to the agreement, nor did they provide any consideration. Although the arrangement was intended to benefit Ida and Hafiz, mere benefit is insufficient to confer legal rights. Their claim is therefore based solely on their status as third-party beneficiaries. It may be argued that this agreement constitutes a family arrangement and should be enforceable. However, family arrangements are generally presumed not to create legal relations. This principle is supported by the case of Balfour v. Balfour, where agreements made in a domestic or family context were held to lack legal intention unless there is clear evidence to contrary. In the present case, there is no evidence that Rahman and Johan intended their agreement to be legally enforceable by the children. The agreement appears to be a moral or social promise rather than a legally binding contract. It may also be argued that Johan's estate has a moral obligation to honor the promise. However, moral obligations do not amount to legal obligations under contract law. In conclusion, although the promise was made for the benefit of Ida and Hafiz, the doctrine of privity of contract prevents them from enforcing the agreement. As such, Johan's executor is not legally obliged to pay the 50,000 ringgit Malaysia wedding gift. I will now pass the presentation to the next speaker, Mukhlis, who will address issue 3 and issue 4.
My name is Mukhlis bin Maizan and I am going to continue with the presentation. My part is on issue 3 and issue 4. Now, issue 3 is about domestic and social agreement under intention to create legal relation. The issue is whether the promise from Aida's mother to pay 2,000 ringgit monthly constitutes a binding contract and is it enforceable by law. The relevant law and authorities under this example is Section 2D of the Contracts Act 1950, which gives the definition for consideration. And in simple terms, consideration is something done or promised in return for a promise at the desire of the promisor. Now, for the relevant case law in this situation, we can look at Balfour and Balfour 1919, where the facts are husband and wife were living together as a married couple. When the husband was working overseas, he promised to pay his wife monthly allowance. Their relationship later deteriorated and the wife took action to sue for the unpaid amount. The thing that we have to focus on this case is the fact that at that time, the wife and husband are living together. Now, the issue in this case is whether a promise made between spouse during a normal marital relationship is legally enforceable. The principle of law that has been highlighted in this case is agreements made in domestic context generally does not show intention to be legally bound, and these agreements are often based on mutual trust and affection rather than legal obligation. So this case highlights the general rule when looking at domestic agreement. The judgment in this case also states that the court held that no binding contract existed between the parties and the husband is not legally obliged to pay the wife. Now, there are exceptions to this rule. We can look at married and married 1970. The facts are the husband and wife were separated. Husband signed a written agreement promising to transfer the house to the wife. Wife paid the mortgage installment as agreed, and then the husband later refused to transfer the property. Now, the issue in this case is whether the intention to create legal relation existed between separated spouses. So the difference between Balfour and Balfour is the fact that the wife and husband are separated and the agreement was made properly on a written paper. Now, the principle of law highlighted in this case is domestic presumption does not apply where parties are separated, an agreement is made seriously and formally, and intention can be inferred from conduct and reliance. The judgment in this case, the court held that the agreement was legally binding. The husband was ordered to transfer the house. So this is the exception for the general rule. Now for the application, in this case, it is a domestic agreement between Ida and her mother, and in general, a family agreement is not legally enforceable, as we have seen in Balfour and Balfour. Now, however, in this situation, Ida acted to her detriment by resigning her job and giving up stable income to continue her study in law. This action is more similar to the case of married and married, in which parties show clear reliance on the promise. The promise between Ida and her mother involves a monthly allowance of 2,000 ringgit until she graduated. Ida's mother, at this point, when the dispute arises, already paid Ida for a year before the dispute, showing that the mother has clearly shown intention to be legally bound. You can also look at consideration under the section 2D of the Contracts Act 1950. Ida's action of quitting her job can be amounted to a consideration. So in conclusion for this issue, the case shows clear intention to be legally bound by Ida and her mother, thus forming a contract between Ida and her mother. Her mother thus is liable for breach of contract. Now moving on to my next part, which is on the fourth issue, which is on government scholarship bond. The issue in this case is whether Ministry of Health's demand for Ida to pay for the entire bond amounts to a penalty. Because in this case, I argue that the terms are unreasonable and is a penalty. The relevant law and authorities in this case is seen under Section 5 of the Contracts Act, Amendment Act 1976. When the scholar breaches a scholarship agreement, he is liable to pay the appropriate authorities the full payment or a stated amount, and no deduction of pay shall be given for partial service. And Section B, if no sum is mentioned in the agreement, the appropriate authorities is liable to pay the whole sum expended and the additional cost needed to replace the scholar's service. Now for the case law, we can look at University of Malaya and Lee Ming Chong in 1986, in which the defendant received overseas scholarship. The bond required 5 years of service, but the defendant left after only 2.5 years. The plaintiff demanded payment of a fixed amount. The issue in this case is whether plaintiff partial service discharge liability under a scholarship bond. The judgment is defendant was liable to pay for the full amount. Scholarship agreement is valid and enforceable. The principle of law highlighted in this case is partial service does not reduce liability, and scholarship bonds are statutory contracts, not penalties. So applying this into the case, Ida entered into a scholarship bond agreement with Ministry of Health, requiring her to serve for 5 years. However, in this situation, Ida has breached the contract by working for only 2 years. Under Section 5 of Contracts Act, Amendment 1976, when a breach of contracts happen, the scholar is liable to pay for the stated amount in the agreement. You can also look at the case of University of Malaya and Lee Ming Chong, in which the court held that partial service does not discharge liability. The scholar still have to pay for the full bond amount stated in the agreement. The repayment clause was enforceable and not a penalty. Ida voluntarily entered into the scholarship bond agreement with Ministry of Health, but she failed to follow the agreement in the contract. She cannot rely on partial performance to reduce her liability as stated in Lee Ming Chong. Therefore, the government is legally entitled to recover the full amount of the bond. Ida's argument of the bond being a penalty fails as stated before, and the repayment clause is legal and enforceable under Section 5 of Contracts Act Amendment 1976. Thank you.
Good day everyone. I will now address issue 5, which concerns a house purchase negotiation between Ida and Laila and focuses on the effect of a counter offer in a contract law. There are two issues to be determined. First, what is the legal effect of the counter offer or an original offer? Secondly, whether Ida can later accept Laila's original offer of 500,000 ringgit Malaysia after making a counter offer. According to Section 2, Subsection A of Contracts Act 1950, an offer is a proposal made by the one party to show their willingness to do or from abstaining from doing something by getting the consent from the other party. According to Section 2B, acceptance occurs when the offerer signifies assent to the proposal. The case laws that can be interpreted is the case of height and range, which establishes the counter offer amounts to the rejection of the original offer, and once it's rejected, the original offer cannot later be accepted unless it is renewed by the offerer. To briefly explain what is the case of height and range, range offered the small is farm to height for $1,000. Hyde rejected these and counter offer $950. Ranch refused. Hyde then attempted to accept the original offer, which is for the $1,000. The court held that no binding contract existed as the counter offer had destroyed the original offer. Therefore, the principle is very clear. A counter offer terminates the original offer. Applying these case laws and these sections to our scenario, where Laila made an offer to sell the house to Ida for 500,000. Instead of accepting this offer, Ida proposed to purchase the house at the lower price. Therefore, it's a counter offer. Applying the case of height and range to Ida, where counter offer operates as a rejection of the Laila's original offer. As once the counter offer was made, the original offer Rm 500,000 ceased to exist in the law. As result, Laila was no longer obliged to keep the original offer open. Since the counter-offer had terminated the original offer, Ida cannot later purport the accept of around 500,000 unless Laila expressly renews or re-offers it. There is an indication that Laila renewed the offer, therefore no valid acceptance occurred under Section 2B of the Contracts Act 1950. In conclusion, for issue 5, IDA's counteroffer is terminated as Laila's original offer cannot be accepted. The around 500,000 offer, no binding contracts laws were formed, and Laila is legally entitled to refuse it. Thank you. To conclude, the scenario involving IDA demonstrates the importance of the core principles of contract law under the Contracts Act. Across the issues we discussed, we see that clear promises and full performance can create a binding unilateral contracts. Third parties are generally prevented from enforcing contracts due to privity. In the third issue, family arrangements often lack of legal intention. Penalty clauses are enforceable but subject to judicial control that we can interpret from the fourth issue. And crucially, from the fifth issue, in negotiations, a counter offer will immediately terminate an original offer. Overall, this scenario highlights that the contractual rights depends on the strict legal requirements, not merely fairness or expectations. Parties must prove that to exercise these cautions, especially during negotiation, as a single counter offer, which may result in the loss of valuable legal rights. Thank you.